Welcome back, beautiful people out there. Missed you guys. My name is attorney Roxell Richards. I am the founder and managing partner of the Roxell Richards Law Firm, as well as GetInjuryHelp.net. You can follow me on social media where I post daily at Get Injury Help. Now, this episode, as well as the next episode, I will be discussing food allergy claims. As you know, the Gavel is a place that we come together and we talk about different injury case types under which you can pursue a claim for monetary damages. We also discuss the legal theories in plain and simple terms that me as your lawyer would use, or another lawyer out there would use, in order to assert your legal claim. Now, the reason why I chose food allergy and specifically is because I had a client walk through the door, and this particular set of facts were interesting nevertheless, but I felt that it was actually the set of facts that I could actually use to bring a claim on her behalf for her food allergy reaction that she suffered against this restaurant. And so because this was the first time I was presented with this type of claim, I had to do a bunch of research, and of course it's of benefit to you all because I can kind of use my particular circumstances to help you guys understand this type of legal claim and the different types of legal theories that would apply, and as well as it would help some other lawyers out there. Now, let's talk about the facts. So, in this particular situation, you go into a restaurant, probably one of your favorite restaurants. You see a dish, you keep your eye on that dish, and that dish is just appetizing, right? It's just mouth-watering. And so now you want to purchase this particular dish. But you do have a food allergy. And in this particular situation, that food allergy is shellfish. So what do? You tell your server, hey, I like this dish. Does this dish contain any sort of ingredient of shellfish? The server tells you no. You then go back and you ask the server, hey, could you go into and ask the chef just to confirm that this particular dish does not have shellfish because I have an allergy. They go and check this out and go into the back of in the kitchen. They ask the server. They then come back out and then confirm to you and tell you, no, this dish does not have shellfish, so you're good to go. You can buy it. What do? You buy the dish. And lo and behold, what happens next? You become deathly ill, have to go to the hospital, and you suffer a allergic reaction to this particular dish. And unfortunately, it contains exactly the ingredient that you asked the server, which is shellfish. What do? You go see a lawyer, and you want to ask that lawyer, hey, can I pursue a claim against this restaurant for the horrific injuries that I have suffered, which is my allergic reaction to this dish that I was given that contains shellfish? And in this particular set of circumstances, as well as in my client's particular circumstances, I spotted two legal theories that you can bring forth at the very minimum. Now, I always spot more, but these are the main two that really rung a bell and that I actually found some case law out there. The first one is negligence, and the second one is DTPA. What is DTPA? That is Deceptive Trade Practices Act. Now let's talk about what the first legal claim means, and let's talk about what we need in order to prove that. Let's talk about the first legal theory of negligence. Okay, now negligence is going to be the legal theory that I am using in order to hold the restaurant in this particular situation liable so that the plaintiff can then request damages from the jury for what she's gone through. And in this particular situation, it's the allergic reaction. And you know, she was in the hospital, so of course there's going to be some medical expenses, some pain and suffering, some mental anguish, possibly some other damage elements as well. Now, Because we are asserting the theory of negligence, with the law requires certain elements under this particular legal theory to be met. Now, for negligence, there are 3 elements, and let's talk about them. The first element is that the defendant owed a legal duty to the plaintiff. And in this particular set of circumstances, we're talking about what is the legal duty that the server owed to the patron, in this situation, the young lady who suffered an allergic reaction. Number 2, that the defendant breached that legal duty owed to the plaintiff, and in this particular situation, the server breached that legal duty owed to the young lady. And then the last element is that that breach proximately caused the plaintiff's injuries. Those are the 3 elements. Now, there are some trigger words that we talked about, and I'm going to explain those to you in as very simplistic terms that I possibly can. The first one is the legal duty. Remember, we talked about the first element, and that is that the defendant owed a legal duty to the plaintiff. What is legal duty? And we're going to talk about what that definition is right now. Let's look at the screen. A legal duty is a legal obligation that requires a defendant to conform to a certain standard of conduct to protect others against unreasonable risks. Now, duties can arise either by statute or common law, meaning that the courts have established this. Now, when we say statute, what does that mean? That means that the defendant has a duty because the statute mandates them to act a certain type of way to prevent certain types of foreseeable risk of injuries towards others. Common law is those duties that's prescribed by the courts because of all the litigation that we've had over the years, and these courts have pretty much prescribed certain standards of conduct that would apply in certain types of circumstances. Now, in this particular situation, I am going to issue spot that the defendant had a common law duty to act within a certain standard of care to prevent the foreseeable risk of injury to the plaintiff. And in this particular situation, we're talking about the foreseeable risk, which is the foreseeable risk of the plaintiff suffering an allergic reaction to this dish that she is offering her to purchase. Now, what is that duty mean under common law? And let's talk about it. The duty to exercise reasonable care to avoid a foreseeable risk of injury to others. And in this situation, that simply means that this server had a duty of care, of ordinary care, right, to ensure that this particular person who's already told her that she had this food allergy to shellfish, she was supposed to act accordingly to ensure that she doesn't have this reaction to shellfish, and she ended up having it. So she was supposed to conform to a reasonable standard of ordinary care. Okay, that's the legal duty first. So we've met that. Now, let's talk about that second element. That second element is that the defendant breached the legal duty owed to the plaintiff. Now, when we talk about breach, what does that mean? Okay, what we're talking about when we're saying that the defendant breaches legal duty, we're talking about whatever that conduct is that the defendant did towards plaintiff, that conduct did not meet a certain standard of care. And in this particular set of circumstances, we're talking about the standard of care that the defendant needed to act or meet is to act with ordinary care. Well, let's talk about what that means. And this is mostly what most of us lawyers use in most circumstances, to act with ordinary care. Let's talk about what that means. When a duty requires a non-professional to exercise ordinary care, the defendant's standard of care is defined as what a person of ordinary prudence would or would not have done under the same or similar circumstances. Now, here's what we need to know. Sometimes the conduct may not be within the common sense of, our jury members, or within, the common sense of a lay person. And in certain circumstances, the expert has to be used in order to state what that certain standard of care was that the defendant should have risen to, that would have, had they done so, it would have prevented this particular injury that plaintiff is suing for. But in this particular set of circumstances, we don't need to use an expert. Now, what I do is I always try and use experts, if I can. But let's say, for example, in this particular set of circumstances, this is within the common sense of all of us standing here today. Okay? And what does that mean? Well, the defendant in this particular set of circumstances, they breached it. They obviously did not use ordinary care. What could they have done differently? Well, they could have gone to actually see the list of ingredients that this dish had. They could have confirmed that. They could have taken their time. Obviously, that was not done, and they breached that legal duty owed towards this particular young lady who told them that she had a food allergy, who then asked them again to confirm those ingredients. And there was this breach that occurred, obviously. Now, here's what you need to understand whenever we're talking about negligence. We're talking about accidents, right? Because they happen for all sorts of reasons. Obviously, this is not something that was intentional, right? Then we would be in a whole different set of, body of law that I don't practice. We're talking about civil. And we're here because obviously there was an accident, right? So this particular server did not act with ordinary care and do what another, server would have done in the same or similar circumstances. They didn't act with ordinary care. And in my situation, I would also get an expert to say, hey, what should they have done? And list that out. Now, the last element that we must prove in order to assert your claim and hold the defendant liable for monetary damages in this particular set of circumstances is causation. And that is that the defendant's breach proximately caused the injuries to the plaintiff. And in this particular set of circumstances, we're talking about that the defendant's failure to use ordinary care in telling the plaintiff that this particular dish did not have shellfish, when in fact it did, caused the injuries. And in this particular set of circumstances, we're talking about the injuries that she suffered, this allergic reaction, and her hospital stay was caused by this breach. Now, when we're talking about cause and fact, there are some things that you got to know we have to prove. There's two legal elements that must be met in order to prove causation. And the first one is cause in fact, and the second one is foreseeability. Let's talk about what cause in fact is and what that test means. Now, the test for cause in fact, or but for causation, is whether the negligent act or omission was a substantial factor in bringing about injury, and whether the injury would have occurred without the act or omission. Cause, in fact, must be proved by evidence of probative force, either direct or circumstantial, and not by mere conjecture, guess, or speculation. Now, let's talk about what that means. And this is plain and simple as day. If we're talking about but for, right, this first element, but for the negligent act of this server, a plaintiff in this particular set of circumstances, the young lady, would not have suffered this allergic reaction. How do we get there? Well, but for the server telling her all of the ingredients in this particular dish, she would not have suffered this injury, i.e. the allergic reaction to this dish, which caused her to be hospitalized. So how I do that? I take away the act. And in this particular set of circumstances, we take away the act of defendant telling her that this particular dish didn't contain shellfish when in fact it did. We take that away. Would the plaintiff suffered that allergic reaction? And in this case, no, because she wouldn't have purchased that dish had she known that. So that's how we get there in this set of circumstances. So we have our first element met. The second element we're talking about is foreseeability. Let's talk about the legal definition and apply it to this set of circumstances and tell you what that means. Foreseeability is defined as the plaintiff must establish that a person of ordinary intelligence should have anticipated the danger created by the negligent act or omission. Now, in this particular set of circumstances, foreseeability, we're talking about from the defendant's standpoint. And in this particular set of circumstances, it's foreseeable that this plaintiff would have suffered this allergic reaction. She told the server what she was allergic to. So I would argue foreseeability is met in this situation. So we've got all of our theories. We've got all of our elements met. We've got the duty, we've got the breach, we've got the causation, and now we've got those. Now we can get into our damages. And this is the pinnacle of what your attorney has to do in order to get you to what amount of money you are entitled to under the law. So, I have talked to you about the first legal theory, and that's called negligence, okay? Now we're going to roll over into the second legal theory, and that's called DTPA. Now, here's another legal theory I issue spotted and I would use to hold the restaurant liable as well. And as I stated, that legal theory is called DTPA. That is Deceptive Trade Practices Act. And let's talk about what that law is. Now again, this is another legal theory in which to hold the defendant liable for monetary damages that we are seeking against them. So we already talked about negligence. Now we over here talking about DTPA. Let's define what that means. DTPA 17.46 B24 is a false, misleading, or deceptive act or practice to include failing to disclose information concerning goods or services that was known at the time of the transaction if such failure to disclose such information was intended to induce the consumer into a transaction into which the consumer would not have entered into had the information been disclosed. Now, it's important to note this one particular element within that law. We've got to show that at the time of this particular transaction, and that is the young woman purchasing this dish, that the server knew the ingredients of the dish, right? And she failed to disclose those ingredients to the young lady, and that was done to induce her to buy it. And I would argue, yes, that's exactly what I would argue. I would say she knew the ingredients that this dish had, and for whatever reason failed to disclose those, and she wanted her to buy the dish because she told her she could buy the dish, and my client did exactly that. So that's the other one that I issue spotted. Now it's going to be very, very, very crucial again for your lawyer to know that this particular server knew the ingredients and did not provide those ingredients, and the failure to do so actually induced the consumer to purchase those in this particular situation, the good, which is the dish. Okay, so I know I covered a whole lot to you guys. I just wanted to try and simplify as best as I could to you all what legal issues I would assert to seek monetary damages on your behalf. I hope this sheds some light to some lawyers if you've ever faced this particular set of circumstances. I am going to talk about what exactly you need to bring to your lawyer to prove your food allergy case in the next episode. Again, my name is attorney Roxell Richards. I am here, the founder of Roxell Richards Law Firm. And if you have a food allergy claim that you think you can, use to assert a monetary claim against a restaurant or against the company or whoever it may be, I want you to give me a call at 713-974-0388, or you can go to my website at getinjuryhelp.net. Thank you so much, and stay tuned for the next video because I'm going to write down a list of the exact things that you need to take over to your lawyer to help prove your case. Thank you so much, and I'll see you at the next episode of The Gavel.